So I think that I will introduce Mia, whom I know now for quite a long time, it turns out. We met in 2019. So Mia Korpiola is professor of legal history at University of Turku in Finland. And she has been working on many different subjects, but those that I found extremely interesting is her engagement with privacy, which is connected to the Egodocuments, because Egodocuments are one of the most private sources that there are. And Mia organized a very interesting and I think first of the kind workshop on legal sources as Egodocuments in Turku in 2024, in February in 2024. She is also contributing a chapter on legal history and Egodocuments for the companion for Egodocuments, which is now edited in Brill. And I'm very glad that she agreed to talk to us at this seminar. And so I welcome Mia and everybody here. Thank you for coming. And also thanks to Hadrian for co-organizing this seminar with me. So Mia, the floor is yours.
Thank you. Thank you for the invitation, and I'm very happy to be here today and speak on the topic. I'll try to share my slides. Some technical difficulties I've experienced, but let's try it once more. So can you now see my slides?
It is loading. Yes, now we can see that.
Good. Okay, so I had to find a suitable title for my presentation today. So the only one I could invent was Egodocuments in Legal History Research, Possibilities or Threats. And now I know that there are both legal historians present and then also experts on Egodocuments present. So I'm trying to kind of say something very general so that everyone will understand the position of the other group. So without further ado, let's go to the presentation of today. So first I'm going to talk what legal history is, especially for those who come from other fields. Then also what legal history does and how. Then a couple of words on Egodocuments, even though it's familiar for some of you. Then to the possibilities and threats of Egodocuments. And I'll come with a short conclusion at the end. And this should leave plenty of time for discussion, which is good. So let's move on. First, to the question of what legal history is. So basically, legal history focuses on law using historical methods. And legal historical research can focus on any period of history as long as we know something of the legal system of that particular period, so that we have some sources. And also, legal history can focus on any place on the globe or any region on the globe. You can even do research, historical research on space law if you want. The development of space law, for example, could be a legal historical topic. So then you can actually leave the globe and go into space. Basically, legal historical research focuses on the development and change of law in the past. So what I've said so far is probably generally shared by legal historians, but what does one mean by law is something that probably divides opinions between legal historians, quite a lot actually. So whether one understands law in a very broad sense or whether it should be narrowly defined. And I'm going to present two examples or two perhaps stereotypes on internal and external legal history. Next. So internal legal history or doctrinal legal history focuses on the history of law in the narrow sense. So often it presents a historical trajectory or a genealogy of some kind of legal norms. So how a certain legal institution or legal norm has changed through time. The norms, of course, may differ. So they can be statutes, they can be constitutions, etc., etc. So there is variation. But then also how the norms have been interpreted by lawyers, by jurisprudence, sometimes also through legal practice, especially in common law countries where precedents are important in order to determine how a certain norm is interpreted, or actually sometimes to lay down what the law is in a very fundamental way. So internal legal history looks at changes in law or legal doctrine within the legal sphere. So one could argue that doctrinal or internal legal history is within a bubble, the bubble of law. And what happens outside the bubble of law is really not very relevant for them. So what's in the bubble, that's the law and society, and everything that's non-law is on the outside. Well, internal legal history has been criticized for its isolation from society. And of course, some internal legal historians don't deny that society may have an effect on law, but they don't pursue that relationship between society and law. It can be mentioned, but that won't be a real focus of their research. So internal legal historians tend to find their discussion partners from within the legal science and law, from legal professionals, for example, and so on, which may lead them to be isolated, at least to some extent, from other fields of historical research and historians. So they might not read the same books, they might not go to the same conferences, they might not be aware of the research done by each other, for example. And the British legal historian, has called it a certain insularity and sterility of internal or doctrinal legal history. So doctrinal legal history does normally not analyze the practice of law courts or the activity of law courts more broadly. They might not usually focus on the legal profession because that's not law, obviously. or people of law more generally, and they might not engage in biographical research because, like famous judges or famous advocates or politicians who are also lawyers and so on, because biographical research often or usually includes a person's whole life, not just concentrating on their legal life, for example, and also the person's childhood, education, family networks, friends are discussed. So, and also perhaps political activities or societal impact or their taste in music or literature or whatever might also be a part of biographical research. So perhaps internal legal historians might think that this is too close to interaction with society and too far from law and its interpretation for them to engage in that kind of approach. Then to external legal history, which looks at law interacting with society and looks at law in a very broad sense in various contexts, whether these are political, economical, cultural, or related to social and power structures, or, for example, legal artifacts. And if internal legal history focused mostly on legal sources in the sense that they are usually norms, legal literature, case law, and so on, external legal history obviously uses a broader pool of sources, various sources, in fact. And external legal history might focus on legal professions, which is a rather traditional topic in legal history research or legal work. The functioning of and role of law courts more broadly. Biographical research, the social history of law, perceptions of law, the uses of law, law and literature, whatever, basically. Everything else that legal history does goes to the external legal history category. And legal culture is something that is a concept that has been used already before Lawrence M. Friedman's famous article on legal culture and social development from 1969. But here is a quotation from this article that also goes to show various topics that external legal history can focus on. So he has mentioned what kind of training and habits do the lawyers and judges have? What do people think of law? Do groups or individuals willingly go to court? For what purposes do people turn to lawyers? For what purposes do they make use of other officials and intermediaries? Whether there is respect for law, government, tradition, and also the relationship between class structure and the use or non-use of legal institutions, and so on. So as you can see, here we have moved to rather further afield from what the law actually is and how law should be interpreted. So here we are deep in society, really. So then to the question of Egodocuments. And for the benefits of those who are not experts on Egodocuments, I'll just present very shortly some very basic things, and you experts can then supplement and correct me if I say something stupid here. But usually one uses Jacques Presser's definition. He was a Dutch historian who first used the word Egodocuments. And he defined an Egodocument as a historical source in which the researcher is faced with an I, the ego from Latin, as the writing and describing subject with a continuous presence in the text. And what kind of sources then are usually classified as Egodocuments? These include travel journals, diaries, memoirs, various autobiographical texts, or what is known as life writing. Also confessional texts, for example, for religious purposes, and also private letters. But if this is a generally accepted definition, there have been attempts to broaden the definition to other kinds of sources as well. And various scholars have argued that sometimes wills could be seen as Egodocuments, especially if they are written by the testator, the testators themselves, but also that court records or notarial records could be seen as Egodocuments. And perhaps also whether professional notebooks, such as judges' justicing notebooks, could be seen as Egodocuments if they have been written by the judge himself. And the question arises, especially perhaps in legal history, how continuous does the writing and describing subject have to be present in the text? So I have been reading, for example, the so-called diary of the Nuremberg executioner Franz Schmidt, who kept what is called a diary, but it has very little of. He doesn't use the word I very much. He uses it occasionally, but quite rarely. And he doesn't really talk much about his own feelings about the hundreds of executions and other corporal punishments he was actually performing in Nuremberg during his career of at least 50 years. So can it be called an Egodocument or not? That is probably something that can be debated. So how many times does he have to say I in the text? How much of personal feeling does he have to describe, or he doesn't talk about his personal life in the Egodoc or in his diary at all. Whereas his colleague in Nuremberg, the priest Johann Hagendorn, who actually was the priest who was preparing the people sentenced to death to be executed. So he was preparing their souls for the execution. And sometimes these two men describe the same executions, for example. So one can read them and compare the one to the other. And in comparison to Schmidt, Johann Hagedorn wrote more about his own experience and also sometimes about his private life. Not very often, but still sometimes. So can these be called ego documents or not? How much experience, personal feeling has to be there? That is a matter of taste. I'm not sure what the experts on ego documents would say, but I would probably extend both into the definition of ego documents, but that's a matter of taste, perhaps. So what ego documents could be used in legal history research then? As in all historical research, the use of sources depends on the research questions persons could have, or researchers have chosen. And of course, if one does internal or external legal history, one chooses research questions which either would include more broader sources, while others would only concentrate on traditional legal sources like norms and jurisprudence and so on. But my personal opinion, representing the external legal historians, I would say that any sources that helps one answer one's research questions are valid in legal history research, regardless of what kind of sources they are. So I would be liberal here. Then to the threats of ego documents. Well, some of my colleagues might argue that the use of ego documents means that one is on a slippery slope, that one does not do real legal history, whatever that is, probably doctrinal legal history, and it leads to choosing trivial or non-legal research topics and questions. Because public sources are perceived as more reliable than private sources, and ego documents, as Michael just said in his introduction, are private sources generally. Also, some have argued that ego documents are subjective sources and therefore contrary to objective sources, and as such they are not trustworthy in the same way as objective sources, and that they demonstrate a bias. And that also contributes to the lack that one can't trust them really, they say. To this, I would say that for any historian, source criticism is a very fundamental thing when regarding and analyzing any source. So regardless of what kind of source it is, it must always be viewed with criticism. And one must ask questions like, when is it written? For whom or to whom is the source written? Why it is written, and so on. So this is quite fundamental in any historical research. So I don't see why ego documents should be particularly under the microscope here, because this is historical standard approach to any source. But it's true that when analyzing ego documents, one must ask how authentic it is. Has the source been edited? Because edition is always interpretation. has, for example, the editor read correctly the original document when transcribing it, for example? Has something been deliberately left out as too scandalous or too uninteresting for the editor, perhaps, or something that the editor thought trivial? How secret was the source? How private was it? Or did the author intend it to be printed, for example? I read recently one ego document, diary by Judge Garnet Andrews, and in it he wrote that he did not wish to say anything unpleasant to anyone, and that's why he had chosen to use fictitious names instead of real names. So here the author actually says that he has been censoring himself to some extent. But of course, the same applies to many other things. And I've chosen to illustrate this slide with Samuel Pepys and his diary. He wanted, or his diary was so secret and so private, he did not use ordinary handwriting, but used shorthand, so that a casual observer finding the diary would not be able to read it, for example. So obviously these kind of things must be taken into consideration when analyzing the source. But as John Tosh has said in his The Pursuit of History, bias does not in itself mean that the offending document, in his words, needs to be consigned to the scrap heap because the bias can be historically significant. And especially autobiographical texts are notorious for errors and that they try to present the author in a good light and so on. So, but he concludes this passage saying that even the most tainted sources can assist in the reconstruction of the past. So one ought to be cautious, but not use these kind of arguments to, or as an excuse not to use ego documents. One can also argue that they are not representative, that they only tell about individual experiences and therefore cannot be generalized. Here one can also, when reading these kind of ego documents, one can ask oneself whether it's probable or not that this is only a unique experience, or does it represent perhaps something that was common. For example, there are many persons who have written their memoirs in or some kind of autobiography in prison, for example. So if they have been describing prison circumstances and how they have been treated by the legal system, whether it's probable that this is a one-off individual experience only, or whether they represent something, experiences that were usual or shared by other people in the same situation in that period, for example. And of course, contextualization is also very important in any historical research. So one can read several autobiographical texts from the same period. For example, I mentioned reading Johan Hagedorn's diary and Franz Schmidt's diary against each other. And one can, for example, see what one writes about a certain execution and then compare it to what the other one writes. And also check the facts against other sources, and generally contextualize the ego document with a whole plethora of other sources that one may find from the period. So obviously, I mean, that's good historical research and should be self-evident for any researcher. So again, I don't, of course, there are some caveats, but I don't see that they are reasons for not to use ego documents as sources. Then to the possibilities of ego documents. Well, obviously, they have the possibility to bring fresh perspectives to legal history research. And through ego documents, at least that's my experience, one may get information on things that cannot be obtained elsewhere in any other source necessarily. They also bring legal history alive because one gets insights into lived law or personal opinions, feelings, and experiences regarding law and the legal system from people at the time. And they also may bring an actor perspective in the fore. For example, explaining circumstances behind litigation, experiences of litigation, and motivation for litigation that one cannot understand properly or even know by just looking at the court records, for example. And I think have elucidated the slide here by two ladies, the Swedish Agneta Horn and the English lady Anne Clifford, who both were for a long time, for Lady Anne Clifford for perhaps decades, involved in litigation. Or actually, she wasn't involved in litigation, but the project was going on for a very, very long time. Both had been disadvantaged by their father's wills, and they were involved in litigation to obtain property that they thought that was theirs by law. So their self-biographies or autobiographies really tell how important this was, and the autobiographical texts are really to some extent an extension to the court case itself. So they must be read together, really. And obviously, one also gets behind the scenes views on what happened in law courts or could happen in law drafting, something that left really a really small or no paper trail at all. Something that was so mundane and trivial that it really wasn't worth recording, or no one thought of recording. But then reading, for example, personal letters or diaries or memoirs, one can gain insight that one would not gain anywhere else. And perhaps even though court records have been used a lot to give voice to underprivileged groups, but really ego documents do this without intermediaries. So no court scribe or notary writing the words of the people themselves down, but the underprivileged persons themselves using their own text and their own words that they themselves have written down. That's also an added benefit, I would argue. Then, of course, there are limits to ego documents because they can't answer any and all questions that researchers might have. They leave out self-evident things or things that were known to the recipient of the letter, for example, also so well known to the contemporaries that they didn't even think that anyone would need to get that information because everyone knew that already. And of course, ego documents, what's also relevant is what they do not mention, because this might also show a certain bias. For example, if a person is omitted, that might be significant, or some feel or some happenings that the person is leaving out that but can be accessed or known from other sources might be relevant. So one might actually, instead of looking at the sources through fixed questions that one has formulated in advance, one might actually go first to the sources and look at what can they tell us, and then formulate the research questions, and not vice versa. So that might be useful for ego documents especially. But I would also argue that looking at sources may actually bring new insights and innovative research questions into one's mind. So I would actually also sometimes recommend first going to the sources and then seeing what they can, what story they can tell us and what questions they might answer us. So just very briefly, some conclusions. I would recommend, obviously, using ego documents because they bring new perspectives into legal history research, and they also give us possibility for innovative perspectives and to not to have 21st century thoughts and trying to reflect them into history, but actually that also helps avoiding anachronistic research. Some might argue that the research done using ego documents is not legal history, that it's social history or something else. So I would say that doctrinal legal historians, those who do internal legal history, might not be tempted to use ego documents, but I'm sure that many of my colleagues have an open mind and use happily ego documents, but I would still say that they are an underused source in legal history more broadly. There are, of course, limitations and certain problems or using ego documents, but I would argue that that's nothing that one can't handle with the tools of normal source criticism. And finally, I would say that you can also collect your own ego documents, and that's something, of course, that hearing the coming conference topic of the second conference on ego documents, that one can also use contemporary ego documents such as memoirs or oral history and so on. In written form, that would then be an ego document. And of course, one doesn't even have to collect one's own material by organizing a campaign to collect these kind of memoirs, because so many ego documents are easily accessible in printed letter collections, for example, autobiographies, memoirs, and so on. So I would just say to everyone to go to the library or to the archive and find something to really inspire new research. So thank you for the attention.
Thank you very much. I think it was really interesting and also, I think, very rich, for especially for people who are just meeting the concept of ego documents. But also for me, even though I read the chapter and I know your work on that particular topic, I still found some very interesting things, especially this division between the internal and external legal history. I think that that would be perfect time to have some questions. So I invite everyone to light the cameras on so we can see you. And then we will also gladly have some questions.